on to the next guest speaker, Professor Ila Deshpande from the Law University, Nagpur. Madam?
Yes, sir. Namo Nama.
Namo Nama. I will introduce Ila Sudame and Ila Deshpande Garu. She is the Center Coordinator for the Center for Shastri Studies and Research in Law, CSSRL, at the Maharashtra National Law University, Nagpur. She is pursuing her PhD in perceptual witness misidentification, an inquiry into the legal epistemics based on Shastric and forensic parameters. Her deep-rooted interest in the Indica intellectual heritage made her pursue her learnings in Nyaya Shastra informally from her acharyas. Epistemology stemming from Indic knowledge systems has been one of her major areas of research. She has been mining the Indic knowledge base and exploring its possible practical applications in the contemporary field of law. Her publication in this domain includes a research paper on parameters governing percipient witness testimony in view of Pramana theory of Nyaya Shastra. She has been a member of the Board of Studies on Indian Jurisprudence in Kavitula Guru Kalidasa Sanskrit University, Rompek. Apart from this, her pursuit of knowledge is from field of forensic science, specifically in forensic psychology, forensic linguistics, psycholinguistics, and pragmatics. Owing to this, she holds a certificate of achievement in the FIS online peace investigative and interviewing solutions offered by Forensic Interview Solutions, Washington, D.C., USA. She is currently also pursuing an advanced diploma in criminal law and forensic science at the Directorate of Distance Education, NALSA. She could receive a formal training in the technique of mind mapping by one of the associates of Tony Buzan, the inventor of mind maps. She was involved in the evidence of law research that was initiated as the beginning project of the Pamligantam Kodandaramaya Center for Indic Studies in Law and Justice. She is now going to share her experience with the project. Over to you, Ila Deshpande.
Yes, sir. Thank you so much for your kind words. And I'll just start sharing my screen. Yes. Is it visible, sir?
Yes.
Okay. So with my pranams to everyone present here, the panelists, the presenters, Nagraj sir, when Srinivas ji contacted me for this conference, he asked me to give him a topic on which I would be speaking. And the task of culling down on a topic was actually done so rightfully for me by Nagraj sir. And he wanted me to speak on my experience with the Law of Evidence project of Indica Center for Law and Justice. So this, I think, I have taken up a big responsibility on behalf of many, that I am presenting about this project today. And there are a number of contributors in this project, which eventually through my presentation will be certainly made known to you all. And so with the blessings of Nagraj sir, because he considered me to be fit for giving an exposition about this project, I would like to start sharing. To start with, I would like to discuss the background of this project, why this project, and what made Indica Center for Law and Justice take this up. So basically, as we have discussed till now in this conference also and earlier in multiple occasions, that Indic knowledge systems have really lost their importance in the times of colonization, and modern theories, be it from any discipline for that matter, have been basing out of the Western concepts. So in view of this, that the Indic knowledge systems, which are actually the time-tested indigenous systems of knowledge, which lost practices in the era of colonization and modernization, and in which, in fact, are so potent with theories, concepts, methods, and practices which can enhance any discipline and make the discipline progress in the most logical and effective manner so as to cater to the society and its requirements. Centers which were based on this interface of study, which specifically relates to law and Indic knowledge systems, such kinds of centers came to be established in our country. This is a very recent development that I'm talking about. So, identifying such an ignorance, so much. So, realizing the loss of this knowledge base, loss of the significance and importance being attached to this knowledge base, and progressive importance being given to the Western theories, which in their own way should be credited for where we are. However, our theories, our indigenous theories stemming from the Indic knowledge systems, are, like I just said, highly potent with the theories, methods, concepts, and practices for the development of any discipline. And identifying this requirement, the research centers, that which is a very recent development that came to be established by premier institutions like Indica, maybe national law universities and Sanskrit universities taking up this cause. They started recognizing the importance of this. And what happened when Center for Indic Studies in Law and Justice, which is a collaboration of Indic Academy with the JPKR Foundation, they initiated this project on law of evidence, which had to be a comparative study with Indic jurisprudence. So this was something very novel coming up to the field of law, and at the same time for Shastric scholars also. So to look at our Shastric heritage for being mined from the point of view of giving a practical utility to all these theories into the field of law, and maybe take it to the courts tomorrow, we never know. This project was conceived. So we started off at a very basic level, like the title itself reveals that this is a comparative study with Indic jurisprudence. So the basic objectives that were called out for this project included to analyze the Indian Evidence Act 1872 in the light of philosophy of law of evidence, then to institute a comparative study of the same from Indic knowledge base, to mine such areas of Indic knowledge systems that have the potential of supplementing necessary parameters wherever they are relevant, and to document the entire exercise, to document the examined parallel concepts, definitions, ideas, methods, whatever the scholars may have considered to be relevant to the law of evidence, that was required to be documented under this project. So going further, certain centers joined their hands with this project. It came to become a joint collaboration, and for this project initiated by Indic Academy Center, Kavi Kulguru Kalidas Sanskrit University at Ramtek through its PV Kane Center for Indological Studies, and Maharashtra National Law University Nagpur Center, which was envisioned by Justice Bobde, the ex-CJI, the Center for Shastric Studies and Research in Law. These centers came together and collaborated for the project. The team of this project was considered to be necessary for organizing this project in a very effective manner. So, like we all know, the visionary of this project is Honorable Shri Justice P.S. Narasimha sir. And back then, when I think this was around the COVID time that we were, applying our minds to this, and we started off with this project. Back then, Justice Narasimha sir, he was the Additional Solicitor General of India. And the vice chancellors of both these universities, that is this, no, this was another unique collaboration. We don't get to see this everywhere. Sanskrit University at Ramtek, that is Kavi Kulguru Kalidas Sanskrit University, the then vice chancellor of this university, Professor Dr. Srinivas Varkhedi, and Maharashtra National Law University at Nagpur. came together to patronize this project. So this was a unique confluence of expertise. Then the visionaries and the patrons considered it important to have a team, and we had Professor, like Nagraj sir has already spoken of, Professor Penna. We had, as the director of the project was Professor Penna. Additional directors were Professor Himanshu Pandey from NLU Nagpur. We had MIT School of Vedic Sciences, Professor Sai Susarla with us. Members of the executive committee were came from the legal background. They were practicing advocates of Supreme Court, some other high courts, academicians, and some scholars who were correctly identified to be, they came correctly within this interface of study of law and Shastras. So these were trained in Shastric fields also, and were also pursuing their modern legal education. So professors from both the universities, lawyers, and these scholars formed a part of the executive committee of this team. These now the pearls of wisdom coming were from these Sanskrit scholars who did a brilliant job in this project. They were the ones. Was someone saying something? Okay, so the entire task that was carried out in this project upon this organization was done by these Sanskrit scholars, and they were the ones who went back and mined the entire the knowledge base that is available with us and came to us. So what I want to highlight today here about my experiences is the unique format. Now, why this is required to be highlighted. This is a very unique area of study. So this requires very specific areas of confluence of expertise, one, and adopting a format which is to be specially designed to suit the requirements of this project. So we have people coming from Shastric backgrounds and we have people coming from legal background. So both of us are required to understand each other's discipline. Although in my presentation also eventually I'll be discussing how it was easier for the Sanskrit scholars, but for us as lawyers it was slightly difficult because of the language barrier. So we had to come up with a specific format to effectively carry out this project. So we conducted this in phases. What were the phases? The first phase involved introducing the Indian Evidence Act 1872 to Sanskrit scholars. Now, this was one of the very wonderful, beautiful exercises carried out, envisioned by Narasimha sir, Justice Narasimha. And he was the one, we looked at it from different angles, what to explore, whether to go to lawyers first or to the Sanskrit scholars first. And it was his vision that let us take our knowledge base, let us take the law to the Sanskrit scholars. So we started with in the phase one, where we introduced and we gave an exposition of Indian law of evidence to the Sanskrit scholars, the team that we had on board with us. In the second phase, these scholars, a workshop was conducted for these scholars where they went back with this exposition and they mined Indic literature for the parallel and complementary parameters for or concepts from the Indic knowledge base. So that was the second phase. And now today we are in the third phase of this project, where we are trying to develop that, where we are trying to compile this entire exercise and develop a knowledge product out of it. That is the third phase of this project. So this was a very peculiar format that we took up, and it was highly effective and brilliantly envisioned by our visionaries. So going into the details, I'll quickly go into the details before highlighting certain very important aspects about this project. The first phase of this project, which involved the exposition of Indian Evidence Act 1872 to the Sanskrit scholars, we conducted a series of lectures for a period of 1 week, that is 7 days, and the lectures were delivered by leading practitioners of the Supreme Court, practitioners from other parts of the country, professors of National Law University, Nagpur, and such others. So we had divided the Evidence Act into 7 parts, or these expositions were divided into 7 parts. So these 7 days extensively the Sanskrit scholars sat with us and read the Evidence Act with these experts. So the actual practitioners from the court came forward to the Sanskrit scholars, and the Sanskrit scholars really applied their mind and tried to understand what our law is today. What is India following when it comes to the practices of leading evidence in courts, and what is the entire philosophy behind this act? So this was done. Apart from this, these are not the only experts. We also had on board vice chancellors of some universities and some other experts from this domain, which our visionaries considered to be important, that they address us as scholars, and wherever they had doubts, those doubts were resolved either by the experts on board with us, or by inviting somebody who would have been more appropriate to help them understand the act. So this Vyakhyan schedule was followed at these Sanskrit scholars, highly commendable that they sat with us for 7 days and they understood the Indian Evidence Act. And going by what I feel today, they may be understanding it more than the lawyers today practicing in the court, because they have applied their mind to this act so brilliantly and so meticulously. So this was the first phase. In the second phase, what we did was we did a topic-wise grouping of scholars, these scholars. So these scholars were divided into 4 groups and topics were allotted to them. In the second phase, they were required to go back in their own groups, they were required to mine the Indic knowledge base extensively from wherever they could find out relevant comparative concepts. We call them comparatives. Wherever these comparatives are available in our Indian knowledge base, they were required to come up with all references. So this was an extensive survey of literature that they did on specific topics given to them. They sometimes it also happened that they chose topics that they were comfortable with, but at times they were mostly speaking, they were open to any topic coming to them. So for example, the interpretation clause or the definitions of the act were taken up by one group. Then facts, the proof of facts, relevancy of facts was taken up by one group. Then we came to burden of proof, presumptions, that was dwelt upon by another group. So that is how group wise classification was done, and those groups dwelled upon it. How did they dwell upon it? We had for drafting a comparative study in accordance, in order to give it some uniformity, we had drafted a standard operating procedure which was handed to all these scholars. So this SOP was drafted very meticulously, and the SOP provided them with all the procedures which are required to be followed in drafting their comparative study of law of evidence and Indic knowledge systems. So and the SOP had scope. This was a very interesting SOP. It had also scope for the research scholars to give their own insights wherever possible, because we did not want to miss out on any input. It is quite possible that a comparative does not come up from the Indic knowledge systems. So they were also given scope to record that and find and record what can be the scope of further research in case there is no comparative found in the Indic knowledge systems. So it was a very systematized documentation of survey of literature, and the method and the comparatives were culled out very methodically. What happened in this process was we came up with a very dedicated resource bank of references through the footnoting that they had done. So it is not just what they observed and what concepts they found relevant, also the ancillary incidental ideas occurring to them and the references of that. We have thereby developed a very resourceful bank of knowledge from this particular exercise only. So to give you an example, what kind of questions they were required to answer going by the SOP of this project was whether there is a comparative in Indic knowledge systems. If yes, which is the area? Whether it is Nyaya Shastra, whether it is Dharma Shastra, whether it is Artha Shastra, or anything that they may be referring to. Then any related knowledge system which the scholar proposes to discuss. So this scope was also given to the researcher. The scope was also given to the Sanskrit scholars, because we had faith in their way of thought. This really worked for us. We had faith in their thought processes. So we gave them a scope to express something that they found relevant also. And like I said, if there was no comparative found, they were given a scope to express what can be the scope for further research. Now, in phase three of this process, of this project, phase three execution basically now involves what we have today is this entire survey, this knowledge bank that the scholars have come up with. And in phase three, what is required to be done now, the path ahead is identifying the relevant and substantiating indic parameters from the study, studying their scope of contribution to the act, documenting the entire exercise, and forming a draft of the comparative study based on indic principles for law of evidence. This is phase three, and this is where we are finding ourselves today, all the scholars and the entire team. And having discussed this project, now I would like to come to a very, important part where of this presentation of mine, where I feel, where I want to highlight certain very important aspects when it comes to, like I said, this interface of study has to be very uniquely addressed, approached, and it was done so in this project. The visionaries and the team was very particular about maintaining that kind of the necessities were looked after and requirements were taken care of very meticulously. The first highlight of this project was that the field of law, the legal researchers, reached out to another discipline. Now, this has not happened very often. We as law practitioners, we as academicians of law, we have read our books, we have read our commentaries, we have relied on them extensively. Our judges have brilliantly applied their minds to law. However, there was there is a trend of multidisciplinary, interdisciplinary research is happening. In the field of law, slightly we were on a back foot, that how does this even help us? But in this project, legal research reached out to its allied disciplines. Secondly, what happened was, when it was reaching out to its allied disciplines, it preferred indic knowledge systems over and above the Western methods and theories. So this was another highlight. Multidisciplinary studies are happening wherever we are finding difficulty, we are reaching out, but then we are reaching out the Western knowledge base. In this project, we made sure that it was all indic knowledge base which was explored, as opposed to the contemporarily popular systems of knowledge. So those have been read, those have been done with. We have material compiled on those systems. However, we explored what was lacking. Thirdly, this project has very beautifully opened a dialogue between Sanskrit scholars and legal experts, which was again the need of the hour. Because in order for any discipline to develop, for any discipline to progress, you need to open the dialogue with the experts from other fields. So this project provided a platform. The team, the visionaries, gave an opportunity for the Sanskrit scholars and legal experts to come together and start talking, start discussing the issues of these disciplines. Fourthly, the Sanskrit scholars brilliantly took up the study of Indian Evidence Act, which has never happened before. So they were kept up with such nuances of this Indian Evidence Act that maybe a scholar from the discipline of law may not have noticed, but in the during the Vyakhyan and also during the workshop, they could appreciate such niceties of the Indian Evidence Act and also understand where it may be lacking, if it is lacking somewhere, for exploring the comparatives that they were required to. Fifthly, the legal experts were discovering comparatives from IKS. So the legal experts were on a journey of discovery in this project. So what these Sanskrit scholars were coming up with was a discovery for the experts from the field of law. And we found out that there is so much that can be explored, and there is so much that can be actually done. Then, going by the exercise which was required to be carried out by the Sanskrit scholars, there was an extensive survey of Indic literature done, and specifically relating to Indian evidence law. So when it came to Indian Evidence Act of 1872, we have our references extensively in place with correct, if it is a bhashya, if it is a sutra, everything has been referenced so correctly by the Sanskrit scholars. Then there was an unprecedented confluence of expertise. So when there was a meeting of minds of Shastric scholars and legal scholars, there was the project took itself to another level of understanding our philosophy of evidence, our current methods and practices of evidence, and this was the outcome of this, unique confluence of expertise. And ultimately, we are, like I said, we are in the final third phase of this project, and we are really looking forward to revival of the Indic knowledge systems from to the modern discipline of law, at least from this project. Then, like I discussed, the approach had to be different. So to start with, we had adopted an approach where we took Indian knowledge systems to the lawyers in the first place, and we started discussing this in legal circles and with lawyers, those who were interested in Indian knowledge systems. They took this idea, very well, and they the emotion that was met was with a lot of intrigue, curiosity, that yes, we should do it. But then there was an impediment coming, that we had a language barrier of Sanskrit and we could not read those texts ourselves. So there was this problem coming. Then what we did was, we went the other way around. We introduced the act to the Shastric scholars. So here the advantage was that we got was that Sanskrit scholars could understand the act. We wherever required, we were ready with our Hindi translations also of the act. The Hindi version was also ready with us, that was shared with them. And wherever required, we were we had translators who were doing the job. But mostly speaking, Shastric scholars understood the act very well, and that exercise kind of worked out, as opposed to taking Indian knowledge systems to the lawyers. This was again a call taken by Justice Narsimha, and that did wonders to this project. So coming to this analysis, how I look at this thing, today we are, there is a trend of transdisciplinary research. Come out from law and go reach out to your allied discipline, and then mine and get back to your law, and give it better solutions for its betterment. Now, this is a new trend that is coming up. However, why was it easier for the Shastric scholars? Also because of the fact that this is in fact an age-old Indian tradition, that we are looking at things from every point of view. We have always been doing that. The concept, the Indic idea of Akhanda Vidya, these scholars have already been following that. So for us, it was us reaching out to another discipline. But for Shastric scholars, it was something they were always doing. So they were understanding the epistemology of the knowledge that they were required to apply their mind to. They were understanding the linguistics part. They were understanding the ontology already, because they are looking at it from a very profound point of view. As opposed to the lawyers who have been, we are, owing to our restrictions, we are required to, and our trainings basically, our modern trainings, their trainings are traditional trainings, which make them, put them in a better place. So that was something I found very remarkable, and this approach of Justice Narasimha did wonders. Then coming to the review meetings were conducted when we were doing the workshops, when the Sanskrit scholars would come back to us. In these review meetings, what I observed was, the comparatives that they were coming up with, the Sanskrit scholars, they were coming up with comparatives from such diverse domains, that we would start looking at law of evidence from a very different point of view. Okay, this has this also. So it was epistemology, it was ontology, it was psychology, it was linguistics, it was philosophy, administration. These scholars were addressing all of it. In these review meetings, these scholars were able to give their inputs on all these domains when it comes to law of evidence. So what was happening was, the highlight was that law of evidence was heavily deriving from allied disciplines. So it was parched, basically, when it came to transdisciplinary, multidisciplinary research. And now law of evidence was finding a lot of nurturing from its own allied disciplines, which were also being identified in this project. So another very, very crucial thing to this project was, and what is important for any of such projects, I have felt, is the pooling of human resources and utilizing the human resources to its optimum. Because thus far, what we have done and what we have been limited to, and in my experience of running the Center for Shastric Studies and Research in Law, We came up with the center in 2019, but exchanges, what has been happening, intellectual exchanges that have been happening were mostly based on literary resources, library resources. Then okay, persons, human resources would also be exchanged, where people would come and enlighten, address the students and people from national law universities. However, connecting those minds and coming together of those minds in such a setup, which is not where we are sitting together and applying our minds, brainstorming on certain concepts of evidence from Indian knowledge systems, was happening here. So that is highly crucial to any project of this nature, that these minds come together. And I personally strongly feel that a society should be, formed, where shastric and legal intellectuals come together to, for the purpose of securing societal goals. So simple goals like goals of peace, happiness, through developing the concept of justice from Indic knowledge systems. So if we want to practice ano bhadra kratuyantu vishwatah, for securing, for practicing that, we need to secure the goal of sarve bhavantu sukhina. So for that, these people should come together and form a society and enable the entire exercise of bringing together the knowledge base of Indian knowledge systems and law, and making such projects a success. The bigger picture, if you look at this project today as it stands, the bigger picture when it comes to us is, today where we are at the survey of literature and instituting comparatives. We are done with that. Now I think, I personally feel that this project has a lot of potential to go forward. There are many steps that should be taken, that should be the scholars should apply their minds to. Legal scholars should take up the task of problem identification. Now we have the survey of literature done. Now the problem from Indian Evidence Act has to be identified. The problem identification should be followed by gathering parameters, the relevant parameters from this survey of literature, falling back upon that, and formulation of solutions, and verification of those solutions, and ultimately adopting these solutions in modern legal practices. This is my idea of the bigger picture. I may be, there are many experienced people sitting here and may have a different way, but this is how I look at it, that it should not stop at the survey of literature that we have done. It should not stop at, a compilation, a knowledge product, but it should be taken to the end of adopting, formulating, verifying solutions, maybe through an empirical research, and then adopting those solutions to legal practices. That should be the ultimate end. And I'm sure Indica, we have Nagraj sir with us, and I'm sure he's very enthusiastic about these projects, and this will certainly happen. So the way ahead, how can it really be done? We have been into theorization. Moving from theorization to practical utility, enough has been said. Now we have discussed Shastras, we have discussed all of this. We need to do something about it on a very practical level, and it is certainly possible, is what my research tells me. So for example, I have in my own doctoral thesis, I have explored pratyaksha praman theory for gathering parameters for oral evidence. So in my findings in my research, I have reached such findings upon verification, that it is going to enhance the scientific temperament in the court of law, encourage the spirit of inquiry, and secure objectivity, curtail subjectivity, these parameters, if we truly gather from Nyaya. So if we are speaking of Pratyaksha, if we are saying Indriyartha Sannikarsha Jnanam Pratyaksham, then that it should not be limited to this sutra. It should be brought out, it should be put into the courts and trial courts to see if this can really be tested. So this is taking the legal processes from being purely experience based, which they are, to being experience and evidence based. Evidence we are finding from Indic knowledge systems. So coupling the experience of judges, lawyers with evidence based parameters from Indic knowledge system is certainly, which I feel is the need of the hour. And ultimately what is going to happen is, we are taking care, we as researchers and we as an intellectual society, we are taking care of the major goals of the society, one of which is certainly should be to reduce the miscarriage of justice. So projects like these can certainly contribute, and I think that a day when shastras are practiced in trial courts, in courts of law, should really not be so far. And with that, I would like to end my presentation with thanks to the panelists, Nagraj sir, and thank you so much.
Thank you.
Thank you. Thank you.
Yeah.
Thank you, Dr. Deshpande.
Yes.
Yeah, thank you, Dr. Deshpande, for giving that overview of and so much detail of what's going on. That's very encouraging.